Namaskar and welcome to the discussion on human rights under the preventive detention laws. Friends, to start with, preventive detention means detention of a person without trial, and it may be distinguished from punitive detention. The object of punitive detention is to punish a person for what he has done, and after he has been tried in the court for the punishable act or omission which is done or caused by him. Successive laws have been made to be in force authorizing preventive detention in India, which continues even today in the law known as the National Security Act 1980. The objective of preventive detention is to prevent a person from doing some subversive activities by an order of detention. Such detention takes place in the case on the apprehension that such a person is going to do some act which comes within any of the grounds that is specified by such a law of preventive detention. In fact, preventive detention is resorted to in the circumstances that evidence in the hands of the authority is not sufficient enough to make a charge or to secure the person to conviction by legal proof, but may still be justified his detention on the suspicion that he would commit a wrongful act unless he is detained. Therefore, the law of preventive detention is a very important aspect in relation to the human rights to life and personal liberty, as it would permit a detention for a certain length of time without any trial. Certain safeguards are of course laid down by the Constitution, and the courts would uphold human liberty if the detention is done without following the procedure that is laid down in the Act, which authorizes the detention. Preventive detention laws are in force in democratic countries like England, America, and Canada, but only during the wartime. Preventive detention laws are something unknown in these countries in the time of peace, but in India, while much importance is given to the individual liberty, the preventive detention laws are in operation not only at the time of war, but also during the peace time as well. The continuity of the preventive detention law in India was felt by the constitution makers as an instrument to suppress and control breach of public order and public safety. The reason was that the Republic of India took its birth amidst the antisocial, subversive forces and communal riots. This history repeated, and in order to save India from any such situations, these laws were conferred to the state. The constitution framers subjected the power of preventive detention to certain safeguards, for violation of which such individual will have a right to constitutional remedies for violation of a fundamental rights guaranteed under Part 3 of the Constitution. The law for preventive detention can be enacted by the Parliament exclusively under Entry 9 List 1 in the 7th schedule for the reasons connected with defense, foreign affairs, or the security of India. Further, under Entry 3 of the concurrent list, the Parliament and the state legislatures can concurrently make a law in the preventive detention for reasons connected with security of a state, maintenance of supplies and services essential to the community. The Parliament thus has a wide legislative jurisdiction in the matters of preventive detention for the reasons connected with all the 6 heads mentioned in List 1 and List 3. Besides, the Parliament can, in exercise of its residuary power, enact a law of preventive detention on any grounds. Clause 4 to 7 of Article 22 lay down the provisions of preventive detention and some safeguards. The constitutional provisions is that the government is entitled to detain a person in custody only for 3 months. If it seeks to detain such person for more than 3 months, it can do so after a report from the advisory board, which will examine as to whether further detention is justified or not. Secondly, the person detained shall, as soon as may be, inform of the grounds of his detention, excepting facts which the detaining authority considers to be against the public interest, to disclose. Thirdly, the person detained must have the earliest opportunity for making a representation against the order of detention. A law which violates any of these conditions imposed by Article 22 as stated above is liable to be declared invalid, and an order of detention can be invalidated by an order of the court and set him free. The Parliament has the power to prescribe by laws as to the maximum period of which a person may be detained under a law of preventive detention. Preventive Detention Act 1950 was passed by the Parliament of India, which constitutes the law of preventive detention in the independent India. It was a temporary act, originally passed for only 1 year. Before expiry of the term, the act was extended until it expired at the end of 1969. The revival of anarchist forces obliged Parliament to enact a new act named the Maintenance of Internal Security Act, popularly known as MISA, 1971. Broadly, the Act has similar provisions to those of the Preventive Detention Act 1950. In the year 1974, the Parliament passed the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, commonly known as COFEPOSA. This act is an economic adjunct to MISA, while MISA in general aim at subversive activities. The COFEPOSA aims at antisocial activities like smuggling, racketing in foreign exchange, and the like. Then comes the National Security Act 1980, which conferred further power to the central and state governments, the power to detain a person under preventive detention, to safeguard defense and the security of the country, and to maintain public order, essential supplies and services. In the same year, the Parliament passed the Act on Preventive Detention, namely Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. Since the states of India are also empowered to legislate on the preventive detention, some states of India exercise the power and pass legislations of their own applicability. For instance, Jammu and Kashmir and Rajasthan have enacted state laws authorizing preventive detention. The names of the laws are Jammu and Kashmir Public Safety Act 1977, Rajasthan Preventive Detention Act 1970. Some other states also have passed legislations of preventive detention. The Parliament enacted the Preventive Detention Act 1950 on a temporary basis. It contained a provision saying that a court could not look into the grounds of detention of the detainee. The Supreme Court declared the provision invalid in A.K. Gopalan v. State of Madras, AIR 1950, Supreme Court 27, on the ground that they came in the way of the courts discharging their functions of seeing whether the detention order was bona fide or mala fide, which detention was permissible, or whether the grounds were vague or not, is to enable the detainee to make a representation as laid down in Article 22. The law of preventive detention is very much administrative ridden, as it prescribes no objective standard and leaves to the subjective satisfaction of the executive to order preventive detention of a person. As preventive detention is not punitive but preventive, it is based on suspicion or anticipation and not on proof. It is therefore not possible to lay down objective rules of conduct. However, there are a number of the principles from administrative law which the courts frequently invoke to control the discretion of the detaining authority to some extent. Thus, the satisfaction of the detaining authority can be called in question on various grounds as mala fides, non-application of the authority's mind to the case of the detainee, subjective satisfaction based on irrelevant ground, so on and so forth. It is equally important that discretion should not be arbitrary, vague and fanciful, but should be legal and regular. If the detaining authority has come to a conclusion so unreasonably that no reasonable person could have ever come to it, the court can interfere. In an old case, Emperor versus S. Banerjee, AIR 1945, Privy Council 156. The Privy Council quashed an order of detention order as being issued in a routine manner. In that case, the Home Department of Bengal government followed a practice of issuing a detention order automatically whenever the police recommended it. The Home Secretary did not personally satisfy himself on the materials placed before him as to whether there was necessity to issue a detention order in the particular case or not. The detention was quashed. On the 25th June 1975, proclamation of emergency was issued by the President of India on account of internal disturbances. The President has issued another order under Article 359, suspending the enforcement of Articles 14, 21 and 22 also. The Maintenance of Internal Security Act 1971 was in force. This constitutional safeguards provided under Article 22 was under suspension. After issue of the proclamation, a large number of the persons, mainly political leaders of the opposition party, were detained under Misa. Many of them were not even informed of their grounds of detention. Some of them filed writ petitions in different high courts challenging the detention orders as illegal and unconstitutional and praying for issue of a writ of habeas corpus. The provisions of amended MISHA covering emergency detention, which were extremely drastic and rigorous version of preventive detention, is enacted in MISHA. Only the administration was to have knowledge of grounds and none else, not even the detainee. The provisions were so drafted as to exclude judicial review of any case of emergency detention. The most crucial point involved then was the scope of judicial reviews of detention order issued under MISHA. The question is, can a person detained under MISHA request the court to examine whether the acts of detention were in accordance with the provisions enacted in MISHA itself, under which one has been detained, some of the persons detained, file writ petitions before different high courts challenging the detention orders. Various high courts are found to be in favor of the detained persons. The government of Madhya Pradesh, through the additional district magistrate Jabalpur, filed appeal against the decision of the high courts. The case was ADM Jabalpur versus Shivakant Shukla, 1976, to SCC, PS number 521. The Supreme Court allowed the appeal by stating that when the enforcement of fundamental rights guaranteed under Articles 14, 21 and 22 are suspended by a presidential order during a proclamation of emergency, the detainees will not have any right to question a detention order on any ground. It should be noted that after 1978, by the 44th Amendment of the Constitution, Article 20 and 21 are put beyond the touch of the presidential order. Therefore, even during emergency period, a person's personal liberty cannot be deprived of except in accordance with the procedure established by law. Hence, if the executive has detained any person without authority of any preventive detention law or in contravention of the procedure established by law, which authorizes detention, or the law which authorizes the detention is unconstitutional, the high courts and the Supreme Court may issue a writ of habeas corpus against authority which has kept the person in custody and order the release of the person under detention, whether it is during the proclamation of emergency or in the peacetime. Friends, we can conclude by mentioning some few words. As seen above, preventive detention, which is wartime measures in some foreign countries, is more permanent in India as provided in the Constitution. The Preventive Detention Act has been operative in India since 1950, barring brief gap between the lapsing of the law in 1964 and enactment of the MISHA in 1971. The present law is the National Security Act 1980. There does not appear any prospect of the law being withdrawn in the near future. Thus, it works as a necessary evil. The rigors of preventive detention as it is operating in India is to be checked by the courts. Act as a vanguard of the human rights. Article 22 of the Constitution, which provides some safeguards in the case of preventive detention, is always put beyond enforcement during the proclamation of emergency. Article 21 is now sacrosanct and alive during emergency and normal times as well. And Article 21, which provides as no person shall be deprived of his life and personal liberty except according to the procedure established by law. This Article 21 is an adjunct of Article 22 Even if enforcement of Article 22 is suspended during a proclamation of emergency, the court can always examine as to whether a particular order of preventive detention is in accordance with the law which permits the authority to detain. If it is negative, then the court can put check by judicial order or writ upon the detaining authority to see that it functions within its power and procedure as laid down and not otherwise. Therefore, the access to courts in appropriate procedure to maintain human rights under the law of preventive detention is very practical way to maintain human rights. Thanks. Have a good day.